Hey everybody, this is Raza Lawrence and my partner Allison Margolin. Our Margolin and Lawrence law firm has been operating in Beverly Hills for a number of years, and we have a lot of experience doing criminal defense in both state and federal courts. And we wanted to give you all an overview of how this coronavirus and COVID-19 is affecting the court system, how it's still able to operate despite all of these changes, and some of the things that lawyers can do to help people who are suffering during this crisis and how to sort of work the system. The coronavirus, it's obviously forced everyone to make substantial changes to the court system very quickly. The courts are used to doing things the same way, and they've been kind of stuck in this pattern of doing things for a long time. So it's really interesting to see them changing this quickly. The courts need to operate despite the coronavirus, or else we'll have martial law leading to abuses of power. But courthouses are some of the places most prone to spreading the virus because you have people coming in from all corners of society. You have parties to the cases, you have witnesses, you have judges, court employees, jurors coming from all over the place. And when they get to the courthouse, they're packed together in elevators, waiting rooms, security lines, courtrooms, and then during court, the jurors have to sit next to each other. People are sitting next to each other in the crowd. The inmates go back and forth on buses, so it's sort of like a perfect breeding ground for spreading viruses. So there have been some pretty drastic changes put in place. But one of the silver linings of this whole disruption might be that we're actually learning some things that were inefficient with the court process before, ways we're doing things that really don't make a lot of sense when you look at the bigger picture. And hopefully when we come out of this pandemic, there will be some permanent changes to the good, both in terms of how the court systems work and how bail operates and so forth. So I think a lot of people are learning a lot of lessons about courts and what's really essential and how we can do things better. One thing that's been a big change, documents usually had to be filed in person at a lot of courthouses. In federal courts, there's been an electronic filing system for several years, but in state courts, it's been mostly everything needs to be filed in paper, including some things with original signatures. They won't even accept photocopies, but that's all kind of gone out the window with this coronavirus, and you'll hear a little bit about it, but there's various programs now for e-filing, and so you don't have to file the actual documents in person. Also, traditionally in courts, the parties and their lawyers have had to show up in person for whatever court date, even if it's just a matter of setting dates or having a status conference. People travel from far away a lot of times to go to the courthouse, and it's just a matter of setting a date. I think people are learning that there's a lot of things that can be done through video conference, through telephone, that doesn't really require everyone to show up in person every time to court. So the courts are putting in place new systems pretty quickly in terms of letting people appear informal. You'll hear more about how that works in LA County. The other big thing we're learning is that our jails have been sort of clogged with people who turns out don't really pose any big public threat. Now the different sheriffs and counties have been looking at ways to reduce the population of inmates to release people, both at the state and the federal trial, the federal prisons, especially for people accused of nonviolent or victimless crimes who are simply awaiting trial. In a lot of those cases before, people would get put in jail with really high bails and would be unable to bail out. But now you'll hear about this bail system, how it works, but it's basically zero bail for most offenses. And it'll be certainly an interesting social experiment to see how that works out and whether we can take any of these lessons after the pandemic for reforming our bail system, and whether we've actually been arresting, jailing, and prosecuting people who we really should never have done so in the first place. Maybe there's a better way to allocate some of our resources and to better serve both the offenders and the victims in order to achieve reform. It's it's not just status conference that have been done over video conference. We're seeing, I was just looking at a preliminary hearing in Wisconsin that was going on totally by video conference in a double murder case. There's really a lot that can be done remotely with the court system, except I would say for when you have actual witnesses testifying on the stand, especially in the case of a jury trial, where court cases have said, people need to be able to judge demeanor and be able to really see the people face to face, and also for the defendants to be able to confront their witnesses in open court. It's different to do that over the video conference. But so far, in terms of the courts, they've mostly been continuing everything that they can for several weeks, putting things out into June or beyond. But there's certain things, obviously, that can't just be continued. There's certain things that are urgent, either because someone poses a threat to the public and needs to be locked up to protect people, or there's an urgency when defendants are sitting in custody being exposed to the virus while waiting for a hearing, and they're sort of stuck there, and it's the urgency to get those people out of custody. So you'll hear about how LA has made some reforms in terms of getting the truly urgent matters put on calendar and heard, while stopping the non-urgent matters, stopping those people from coming to court and potentially exposing people and wasting people's times. In LA County, it's an interesting situation here because we have the largest jail in the whole country. We had over 17,000 inmates in LA County when the coronavirus first started. Now we're down to about 13,000 inmates, which is still a lot of people, but there's a significant reduction. I think a lot of that is because of the zero bail policy they put in place. But the LA County Board of Supervisors has basically called for quick studies and efforts to reduce the jail populations. And you're seeing that go on county by county throughout the state, and there's different approaches. We've seen a lot of sheriff's departments we've seen have been very critical of the reforms. I've seen the Orange County and San Bernardino Sheriff's Department have said that it's a real public threat and danger to the public, the zero bail, and it'll be interesting to see how that plays out going forward. We thought we'd go through just this general timeline of what's gone on, how things have changed so quickly over the past few weeks. We have it up on the screen here, but basically it started in early March when Gavin Newsom declared a state of emergency in California, which started triggering all of these changes. March 13th, Donald Trump declared a national emergency. March 16th is when LA County and a lot of the rest of the state began issuing those stay-at-home orders, and things started really changing quickly with the courts. We had the executive order from Gavin Newsom requiring everyone to stay at home except for essential businesses, and courts are one of the essential businesses, so they're allowed to stay open and operate. But you've seen the individual courts putting in place procedures. Every county has their own sort of unique procedures about how that plays out. We're going to look at LA County's rules and how that works.
Raza, can you change your screen sharing? Because I can't share your screen. So to go to like some of the Judicial Council rules when we get to that part.
Yeah, absolutely. We're gonna start with the LA Council at the LA rules, which apply to all the courts in this in the county. But in terms of trials, on March 23rd, an order requiring trials be suspended for 60 days. And especially civil trials have been pushed out a lot. In some in-custody criminal trials, they can't just keep continuing them like that. There's rights to a speedy trial. But basically, we've seen March 28th is when the Judicial Council at the state level issued a series of emergency orders that talk about how the courts are going to operate during this crisis. We're going to go through those. They relate to bail. They relate to how to appear in court and so forth. March 30th, they issued an order that extended the time for holding certain hearings. Now they have more time to send someone to a preliminary hearing and to for a criminal trial. They've extended them more days so the courts can deal with this. One of the results of that is there are people sitting in custody now for longer than they used to be on the serious cases. But this is just because we have fewer courtrooms operating and not as many resources to handle it. Leading up to April 14th, that's when the LA Superior Court issued its administrative order. That's what affects us all who practice in LA County, basically shutting down all of the courtrooms through May 12th, except for certain essential functions. And we're going to go through what those are. So the LA County order, it basically says that all the courtrooms are going to be closed until May 12th unless you fall into one of these categories. Those categories that are allowed to continue operating there's a list of them. It goes restraining orders, civil and family, ex parte proceedings, although there's a way to appear ex parte by phone now if you have a case where you need some relief quick, something urgent. There's a way to set it up by phone in civil cases, which is neat. International kidnapping, that's considered urgent. Probate, ex parte, conservatorship, and then certain criminal processes will keep going: search warrants, arraignments, preliminary hearings, bail hearings, bail review, criminal mental competency hearings, criminal sentencing, criminal post-sentencing, grand jury indictments, certain juvenile proceedings. We'll get into how that's working. And then emergency writs challenging the COVID-19 emergency measures for people who think that the courts have maybe gone too far, or there's too many restrictions. There's a way to get those heard right away through the courts. Emergency protective orders, et cetera. So there's a list of things that are allowed to operate. Everything other than those listed proceedings are going to be continued by the court, and then they'll just send the parties notice of the new dates. Now, over the past few weeks, Allison and I, we've been appearing in court still, mostly by telephone or video conference. The courts themselves have been using Zoom, as well as getting better at teleconferencing. So we've still, on these other matters where the courtrooms are closed, we've still been doing status conferences and making appearances.
Before we go on to our next subject, our next substantive area, I don't know exactly how I can present this, but Raza, maybe there's a way for you to present it, because I was trying to earlier about the article about Zoom and, the issues that kind of arise as to duties of confidentiality and whether or not you can do, anything on Zoom. Are you all able to do like a private communication? Is it private versus obviously having a public hearing? And then I would say the issues with the public hearing are, even if Zoom is fixing some of their security issues, which, Roz, if there's any way you can pull up that article, or Howard, and show it to everyone. But there's a recent article from today about how Zoom is now fixing, some things that we've all heard of, I think anecdotally have happened, or even in the media about, people coming into Zoom meetings and them being hacked. And apparently Dropbox, who is somehow related or owns some stock in Zoom, was basically recently having some kind of contest for people to be able to hack Zoom. And with that data, they've been able to fix a lot of the security breaches. But I think one of the things we encounter here is, what if you want to have, a private communication with your client when it's like through like Zoom at the courthouse and you're not there? And then the other issue is, you want to have hearings where you're not even able to, confront someone like during cross-examination and, do things that you can only do through being there. And then do you want to continue it? And obviously that depends upon the person's custodial status. But these are kind of, I think, some of the other issues that you deal with when, in addition to just these substantive events that we're discussing. So Roz, if you can go through the LA rules, I think that everybody can see your screen.
So that's for the video conferences. Yeah, that's everyone has to make sure that you do it in a way where you're not being overheard by the opposing counsel or the judge when you're talking with your client, that you're maintaining the privilege, and that you're doing it in a secure way. There's instances of total strangers who are hacking into Zoom calls sometimes and listening in and sort of doing things to sabotage them. So I think as we move forward, we'll learn of what the most secure ways will be, and there'll be processes in place. But for now, everyone just needs to be careful to do things in a way to maintain the confidentiality and to do it in the most secure way possible.
I mean, but when you're talking about between calling, let's say using like a payphone in the jail, that's recorded. So that's obviously worse. So that's kind of what I think these are some of the issues that we're dealing with, like when we're not there in person, but literally to be there in person is risking your life and everybody's. And these are some, I guess, ethical things that at least I didn't think we would have to encounter in our practice. Raza, do you want to go through with us some of the emergency rules? I know you're showing us the pictures right now, so if you can.
Let's talk about some of these emergency rules that went in place. This was the state that put these in. There's 12 different rules that cover different things, going from bail to service of documents to extensions of times, etc. But this is what's governing all the courts. So we can go through some of the highlights there. Okay. Anyways, there's different rules. The unlawful detainers, that's not really the main subject of this talk here, but those are basically being continued for several weeks. There's not really evictions going on at the moment under the emergency, and that also raises interesting things for almost everyone in terms of residential leases or commercial leases. Basically, all of those are suspended in terms of having to make payments during the lockdown, and they can be enforced later on. But I believe it's 90 days after the emergency order is lifted is when people can start doing court proceedings again about evictions and unpaid rent. But in the meantime, it's up to people to sort of work things out with the landlord themselves, making payment plans if they can agree to them, or people can just totally forego paying rent until after the emergency is over. But they'll still have the bills due eventually. One of the most interesting rules, let's talk about the remote appearances. Under the new rules, all the criminal court operations are allowed to be conducted remotely with the consent of the defendants, including by phone or video conference. And this also includes that people are allowed to e-file and e-serve documents. So that's interesting. Courts are just sort of figuring this out.
And Ron, I have a question about that, because we've had this issue before. Like, what email are we expected to be, answering? Is it the state bar email? Any email we've ever given to the prosecutor? I know we've had those issues before. What do you think the rule should be? What are our obligations?
That's a good question. I would say everyone should definitely be checking their emails on the state bar website, because that would be the natural place that courts or other attorneys would go looking for ways to contact you. So I would stick with what's in your Bar Association registered email, and to always check those. And also make sure you have a phone number on there that's where people can easily reach you, because everyone's trying to contact each other remotely these days.
And one more thing is just a little practice tip reminder that you should maybe change everyone should change their address for the state bar. When not going to the mailboxes often, then you can always change it back. So we just in a little, thing.
Yeah, we had a little issue at our office. We had some mail that had come a while back, but it had just been sitting a pile at our office, and it was something time sensitive. So yeah, it's a good idea to forward your mail to your home address if that's where you're working, or at least make sure you're checking your office mail on a regular basis. The timing of this, all of these emergency rules really have a similar timing. They're going to remain in effect until 90 days after the state of emergency is lifted. So we could have this for some time, and I wouldn't be surprised, like we said, that a lot of these processes will stay in effect permanently after this, as we realize that some of these changes are actually for the better and more efficient for everybody. The next rule we'll get to is something that's been getting a lot of press attention and affects anyone with criminal clients, as the bail schedule, and how we're basically turning into a zero bail situation for most people except for specific situations. And this is all due to the state emergency bail schedule that's under Rule 4 here, that's been in effect just since April 13th.
Now, Raza, quick question. I saw some people on the California Public Defender Association listserv talking about what should they do if someone files, let's say, a motion for bail review. Let's say it's someone who's in custody, because as we know here under Rule B1 and B2, it applies to both new cases and people in custody. What if the judge puts it over for 2 weeks? Would the next thing be, you think, go do a writ of habeas corpus? And where would you file such a thing for a misdemeanor versus a felony on a writ of habeas corpus? And do you think that's the answer?
Well, first of all, for this new bail schedule that has zero bail, it's supposed to be automatic. Basically, it's not. You're not supposed to have to request a hearing. It's just supposed to be reduced for everybody.
But that's not the case. It's not I know that I just know anecdotally following the chatter that's going on that it's not. So people are having to set the motions. What do you think someone does if they set it out 2-3 weeks and you're worried your client might die just by virtue of being in custody? What do you propose? What do you think people should do?
In that situation, I would say just go up the ladder. Start with maybe the presiding judge in the courthouse that you're dealing with. If you think a judge isn't following the right procedure, and then you could go from there. You could file a writ application.
And where do you file the writ? Let's say in misdemeanor. Let's say in the misdemeanors case versus a felony case.
I know that for misdemeanors, there's a procedure where you can pursue a writ application through the Superior Court, and then generally on felony cases, you go to the Court of Appeal. That's normally how it works.
So that would be that's what we would suggest at this point, be the remedy, and you would just do, what you normally would do. There's definitely resources on the Public Defender Association. Different public defenders have websites. We can definitely, if we don't have it on our website, we're happy to direct you to all different types of motions. And there's also a nice motion bank for federal motions, which we're going to talk about too, on the nacdl.org website. So there's a lot of resources for copies, and you can kind of really see some templates.
And in these situations, I would say it's worth trying a lot of different things just to see what works. I think a lot of people are, doing what they can to sort of bend some of the rules and to help people out in this crisis. So even if you might not have the exact right procedure down, rather than spending a ton of time researching it, go in and, talk to the courts, talk to as many people as possible, talk to the DA's office, and, people can make things happen in creative ways sometimes. And if there's some kind of injustice going on, if you just tell the right people, you're likely to be able to get some people on your side to help affect things for the better.
And one thing that I wanted to mention is you can still have the use of the 170.6. I was seeing in some other states that there were certain judges who were nobody out. But I was thinking about, if you come into a case, obviously you can use the 170.6, but if you're post-conviction and you're setting a bail motion in a court and the judge, you have an off-the-record discussion, they seem like they're not going to let your client out. Do you think you can file a 170.6 in that kind of situation because it's a new judge for the first time, or do you think it's only a pre-trial? That's something to explore. I don't know the answer to that, but something we should look at.
So for the zero bail, there's a list of exceptions of cases where they are allowed to keep bail on the bail schedule, and just go through those quickly. There's, I believe, 13 of them, and it's basically most of the serious or violent types of crimes are the main ones. Are sex offenses. You have anything that's a strike, a serious or violent crime, that still has regular bail. If you have a violation of protective order, even if that's a misdemeanor, that can still be one where you set bail. If you have a felony resisting an executive officer, That's an exception where they can set bail. Witness intimidation that involves force or threats or a conspiracy or pecuniary gain. Spousal rape, misdemeanor felony domestic battery, violating a restraining order with threats, violence, or going to a victim's home or work, felony criminal threats, misdemeanor felony stalking, any crimes that require sex offender registration, felon in possession of firearm. These are all exceptions where they can still have bail. And one of the last exception, which is a little especially relevant here, is felony looting. That's one where they can still put you in custody and on bail. And the definition of looting is any burglary or grand theft that occurs during a declared state of emergency. So those types of property offenses can still have bail set if they fall under this looting definition.
And also, someone just asked, which I thought was a good question. If you have someone out on bail, this was Jesse in the audience. Thank you, Jesse. It says, what about clients out on bail but cannot make payments due to the quarantine? Is there relief for them? Will warrants be issued? So here's the thing. It's a good question. Raza, maybe you could pull up the screen showing how like there was exposed recently. I think it was in BuzzFeed that the district attorneys were trying to come up with a way of still getting like warrants issued that had bail amounts. But now that there was a district attorney that exposed that, and Raza, maybe you can show that to us. Oh yeah, that's another little thing here. It seems that that's not the policy anymore, but regardless, as long as you go in and alert the judge to the issue, I think that you can get them out if they, and also you can prevent them from going in if they can't make payments due to the quarantine. If you have anybody out of custody, actually, it reminds me, we have a client like this who's even had any kind of case, including a probation violation. You should be at the bail reduced to zero. And, you have to do that obviously both on the, the new case and also on the probation case. And it applies to violations of parole, violations of probation, warrants, people in custody, and new cases.
For probation violations, they used to a lot of times put people in custody and not even let them bail out and just hold them for long stretches of time. But that for probation violations, it has to be $0 bail now for all misdemeanors, and including for felonies also, unless it's for one of those 13 exceptions that we went through. If it's one of those, they can still have bail. But otherwise, it has to be a $0 bail for even probation violations. And that was, Allison mentioned what happened. There was a little bit of a scandal. The Los Angeles DA's office, they were published these internal emails where they were discussing strategies to basically get around the $0 bail rule. And it sounded like they were proposing issuing arrest warrants for people and setting a bail amount on those arrest warrants. And that would somehow be a technicality loophole where they could get around these $0 bail and at least hold people in custody until they're allowed to have a bail hearing before a judge, which in some cases could be a few days. But these emails came out, and the head DAs basically had to repudiate them, say that's not in fact their policy, and that they're going to follow the letter and the spirit of the law, the $0 bail law, and they're not going to be trying to use these sort of tricks to keep people in custody against the emergency order.
But they were trying to. So someone just asked, the same person, thank you, was asking what kind of motion should you make. And definitely what I would do is you would make a written motion for someone to be released on their own recognizance, which usually requires like a 48-hour time period. I would then call the clerk of the courtroom. Hopefully they're open. If not, find out where, which courtroom is open that would take this motion in the courthouse, and then fax it to them. Of course, it's very important, the things that, you kind of overlook sometimes when you're not using a messenger, like call the clerk, make sure that they are getting the fax. After the fax, make sure they got the fax, write down the name of the clerk, because you don't want to have a problem where like in 2 days you somehow get, you appear, you think you're going to appear, follow up with the clerk. Usually they're going to send you a Zoom link, all these types of things. So you can definitely, and then obviously you have to have the clerk set up, I guess, something so that the person is going to be able to appear also. Even if you're not going to be there, and you guys are both going to waive your physical appearance. So I would say you should do both a 48-hour motion, make sure that you have the DA gets served electronically, as Raza will discuss. That's the new emergency rule 12 that just passed Friday, and that people are actually getting these things, and people are getting hundreds of things in their inboxes. So communication is, of course, important as it always is, but just make sure people are receiving this, especially when anytime someone's putting in custody, it can be like a death sentence. It's important that these things obviously get arranged that sometimes aren't as big of a deal, but now are.
And I would say, yeah, try calling the clerks. That's been helpful in a number of situations, and if your department's not answering, call the clerk of another department, find which courtroom's open and get the clerks on the phone, because a lot of times they can make things happen, talk to the right people, and help you navigate through these informal processes. And
Raza's right. That's a great idea.
Obviously, too.
Raza's right. That's a really good idea. I think about, like, if you can't find the clerk, find another clerk, not harass them, but, call as many clerks as you need to. And if you need to ask them to connect you, or whatever you need to do just to make sure that you're getting in contact. So Raza, we were going through, where were we here? We were at the exceptions.
So the exceptions, right? There's this list of 13 exceptions that do not automatically go to zero bail, but counties are actually allowed to reduce a bail on even those exceptions. So you might see, some further reductions even for those exceptions. So it's worth looking. It's worth trying, even if you have a case that falls under one of those. Try to get it reduced, or try to do some research to see if the counties change the bail, because it's changing every day.
And Raza, we're going to talk about this, I think, separately, but if someone is in federal custody, Raza, can you maybe put up for us? Oops. Sorry, my dog is barking, one of them. Okay, so if someone's in federal custody, there's also some direction for this. Is that right, Raza? Maybe you can show us the situation there with the William Barr memo. And it's also similar. Raza has it up now on the screen. I think everyone can see it. And this is just a recent memo that basically suggests that you can do, post-conviction and pretrial release for nonviolent people in federal custody, which is tons of people serving tons of time. And there's places like in Louisiana recently where nonviolent people have, started dying. Now, of course, even if a violent person dies, that's horrible too, because even people on death row who are dying, it would still be cruel and unusual for them to be dying of the coronavirus. So there's no life that, should be lost to coronavirus in custody. So this is the direction from the Federal Board of Prisons that Raza has up right now. And
but yeah, there's a lot of federal nonviolent inmates just because of the draconian federal sentencing guidelines, and there's a lot of older and sickly people and younger people too who really are not violent. They're essentially victimless crimes where they're sitting in there for controlled substances.
Because most federal crimes, just when you think about it, most things are not federal that are violent. There's very few people charged with like interstate sex trafficking, kidnapping. That's very rare. Most of the people in federal custody are immigration holds, and the other are controlled substances. So the vast majority will be eligible, and I think what will be interesting to see is where we go from here.
Now, on the federal issues, if anyone's dealing with that, or on the state issues too, a really helpful resource is the NACDL website, National Association of Criminal Defense Lawyers.
Can you show that one for us too? Oh, you're showing it right now.
I don't have that one pulled up, but I know it's NACDL.
Well, actually, that's how you're showing us the Board of Prisons ones come from NACDL.
Yeah, they have links to these Board of Prison memos, but they also have templates for motions that you can use, and letters to send to wardens, different people in the process. They cite the relevant case law, and there's a lot of people who are looking at these issues, and there's helpful resources. You don't have to reinvent the wheel. But this has been in the news lately here, just at our local San Pedro Terminal Island Federal Prison. We've had 2 inmates die of coronavirus there, and 33 positive cases there for coronavirus just at that location. And nationwide in the federal prisons, we've seen, there was a Bureau of Prisons report that just came out yesterday. There's 22 federal inmates that have died of coronavirus so far. And the policy now in the federal prisons is all federal inmates who are just showing signs of COVID-19 are being placed in isolation. But we have the Attorney General. He's issued.
And Raza, one thing I heard this weekend, I was listening to a Zoom webinar by like the UCLA School of Social Medicine, and there were people across the country talking about, litigating these motions in federal court and in state court. And one thing they suggested is that when people make these motions, that they really also talk, of course, about the possibility and probability of corrections officers and their families getting coronavirus from these people. And that even if the court doesn't have, any sympathy for your defendant, they definitely may have sympathy for the, those who will be exposed who are on the law enforcement side. One question we're getting from the audience is from Seth Spiewak. Any tips on helping to get a material witness released based on the danger? And material witnesses released. Oh, that's really interesting.
What do you mean by released?
No, I think he's saying, like, let's say you have someone, you represent a witness who's subpoenaed on a case. Can you get them out of appearing? So what I think you would, I think that obviously you can get them out of coming to court, and most things, Raza, tell me if I'm incorrect, but other than trials, almost anything you can do remotely.
Most hearings are being continued. So I would first of all verify that there's actually a proceeding that's on calendar. Call the clerk, see if they really are taking evidence in hearings, because most everything is being continued. So definitely don't just show up at court, but first confirm whether it's even set, and then I would say go, set up a hearing before the date of their subpoena to try to ask the judge to lift the order or whatever needs to be done.
What he's saying, Seth is saying, if the witness is in custody because they're illegal immigrants. So that's interesting. So the issue is if they have an immigration hold, which usually that doesn't happen in LA, although in other parts of the state it definitely happens, and we have a client in Modesto who's immigration custody. I think that what I would propose that you would have to do is you would go to the federal court, if that's the issue at first, and then try to, explain the situation. And then if they are willing to do it, then the state court judge will probably be, go along with it. If someone's in custody because they're illegal immigrants. Yeah, I think you definitely have a basis. And I know that in New Jersey, Roz and I were just talking about this right before we started. There's a federal judge who released 10 people who were in state custody, but the state, the federal custodial part of the state jail. So I think you would do a motion in, federal and state court.
And the immigration.
If you have any questions, we're happy to help you. We can definitely, brainstorm with you, or if anybody wants to associate us to help, we definitely have time. And we've done motions in state and federal court for all these things through our whole career. Just so you guys, if anybody does want tips later on, I started out my career doing, habeas in the Northern District Court that got certified to the Ninth Circuit, and we're kind of constantly working on these things. So we're pretty much prepared to handle it. And if anybody just wants informal advice, definitely contact us.
Something for any type of motion on this, the Attorney General has given a list of criteria that they look at in deciding these requests. So try to come up with ways to fit your cases into these categories. It's things like the age and vulnerability of the inmate. There's a list of, I think, 7 different pre-existing conditions from the CDC that make people especially susceptible. See if you can find a link to one of those conditions to your client, or if they're above 50 years old. That can be.
It says here, you have to talk about their conduct in prison, and it says people have engaged in violent or gang-related activity within the last year won't get priority treatment under the memo. I mean, that's interesting. So it means if they committed those types of crimes or those crimes in jail or prison, in the federal prison within 2 years, they can still be eligible. So it's actually a pretty loose standard. And we're doing a couple little pro bono, not little, but we're trying pro bono to do, help a couple people right now. And what we started with today was we did a letter to the warden. And then after that, we're trying to figure out what to do. It's in Louisiana, so we'd have to get local counsel there. And that's kind of another issue when you're trying to, help. Obviously, you have to make sure that you're following the bar rules in those states. And even if you're doing a federal type of motion, you have to have local counsel. We have a question here from Sharon. Hold on, let me look. Let's see. How is everyone dealing with repeated requests? Let me see. I'm going to have my daughter help me look at this one. Okay, here we go. Okay. How's everyone dealing? This is from Sharon Buckman. Hello. How is everyone dealing with repeated requests for continuances by DAs to respond to motions to non-emergency matters? Are people just granting the repeated continuances? Can anything be done to prevent them from taking advantage of court closures to perpetually continue their responses?
I think that you could find ways to maybe get cases dismissed. You know, if you don't want to waive time, I don't think you should just automatically waive time as a defense counsel. This could be a good way to get good resolutions of cases if the prosecution is wanting to continue them. But if the person's out of custody, generally we've been agreeing to continue things. But you want to look at if you want to at least think about not waiving time, because this could get a good way to settle a lot of cases and get really good deals that wouldn't be there otherwise.
At the same time, like right now, we have a murder trial. We were supposed to start Modesto, and we don't want to risk ourselves dying in a jury trial. So it's kind of a hard, obviously you have to decide per case what the issue is. And if it's something like in this question that Sharon had, that it's like a motion, I still think you can do motions to compel discovery. And I don't think that the DA has, depending on the DA's excuse, will dictate obviously whether there's good cause, but just like the coronavirus in general, I don't think that will be sufficient, given that, obviously prosecution is considered in law enforcement essential businesses. So I think, evaluating what the good cause is and making sure you don't let, people get away with not having it, as always, is important.
After this memo from the Attorney General from March 26th, there was a follow-up memo April 3rd that actually expands it a little bit and gives them a little bit more flexibility to release people. And basically the latest memo from April 3rd, it says every individual prison basically has discretion how to handle it. It's there's basically unlimited flexibility for wardens of each prison to decide who to release. They make that decision at each institution, and there's no restrictions based on the offense or age necessarily. It's a kind of a case-by-case basis. One issue that's come up for a lot of people have been applying for these loans from the Small Business Administration, and that the criminal justice system is kind of getting in the way of those as well. Basically, if anyone's on probation or parole for any type of criminal offense, the SBA is saying they're not eligible to apply for this relief through this loan program.
Raza, can you show that to us? That article.
Yeah,
here you go. Here you go.
You can see the 2 bullet points there. Those are the questions that people are having to answer, and the SBA is saying that a yes answer to either of those is disqualifying.
One other issue we wanted to address is that there's been a lot of media attention to the, we think, incorrect notion that attorneys who service the cannabis industry, whether it be through like doing compliance or water permits or whatever it might be, there is this, I think, misunderstanding by even law firms themselves that somehow they're ineligible for federal relief, and that's not the case. That law firms are different than other types of businesses. But unfortunately, if let's say you have a corporation that has a 20% owner or more that's on misdemeanor probation, they are ineligible for relief. But that is something that at least we can still do as attorneys, and maybe we can get some business that way, doing motions to terminate probation for people in that situation, because they won't otherwise get emergency relief. That being said, the money is running out every day, and you'd have to do it quickly. But I think that's a huge thing, and it impacts so many people that someone getting off misdemeanor probation, in order to get, a PPP loan or, some other kind of loan, I think a judge would be probably persuaded depending on the situation. One more question we had from Sharon. This is a follow-up. So this is a habeas corpus. The person's in custody, and they keep continuing their response to DA and the insurance said she doesn't want to, or he doesn't want to seem inflexible and upset the judge, at the same time wants to get the guy out. I think it depends on the nature of the offense. Now, just because it's violent doesn't mean it's the end of it. How long have they been in? Their in custody behavior. I think even looking if it's a state motion, still looking at the federal factors, because I think those are important. And if the state doesn't really list factors, which I didn't see any state factors, Raza, correct me if I'm wrong. But I think looking at the federal factors can obviously be persuasive. So if they haven't had, bad behavior in custody, et cetera, even if the judge isn't going to rule on the actual issues that you previously had wanted them to, which were like, the issues of factual innocence or whatever it is, you can still get the person out on habeas, not on the habeas that we're thinking of normally, like habeas corpus, post, plea, but like literally release the body. And here it's because I think it's cruel and unusual punishment for anybody to be exposed to COVID, whether they're, healthy or not. And I think you can make the argument for anybody, given, the mortality rate, the randomness of it, and those types of things.
You also want to look at what's the situation they're going to go back into. That's one of these bullet points that the Attorney General finds important. If you can show a good plan where they're not just going to be on the streets causing problems, but they're going to be with some type of relative or in some kind of secure situation where they're not going to be some kind of menace to society. I think that's important too.
And also, of course, one of the other things is who is the judge. You have to preserve your record for appeal, of course. But here, when, we're talking about day by day is, life or death, we want to make things happen here in the trial court. But sometimes there's things you can do that are like, forum shopping, basically, like maybe in such and such courthouse, you can try in front of the judge you're in, but you can also find out if it's possible to go to the presiding judge, if the presiding judge is good. And then maybe you could exercise a 170.6. That's something I want to look into after this, how you do a post-conviction 170.6 if the judge who does the bail hearings isn't good. So those are all things that you have at your potential disposal.
Allison, do you want to discuss the juvenile situation a little bit?
Yeah, so anybody, I would say, again, for people in juvenile custody, I think that any attorney should have a really decent shot of getting their clients out. It's really, horrible across the country. There's juveniles that are getting it. There are people who can die. I think that we had, for a while, people thought that juveniles couldn't really die of COVID, but they have been. In fact, last week, Charlotte and today's 4/20, so I think it's important. It's fitting to mention Charlotte from the famous strain, medical marijuana strain, Charlotte's Web, just died of COVID-19. And there are people across the country, especially in juvenile facilities. So I think that really anybody who's Raza, thank you for saying that.
And there's some of these emergency rules that deal specifically with that. And there's certain types of hearings that are given priority for juveniles. Let's see.
Anybody, I think, would have an argument to get somebody out. And I think at this point, I don't see why a court for almost any crime would have a problem with electronic monitoring. And I've seen, like in news reports across the city, mostly like on Spectrum, I haven't seen it much in print media, but I've seen like city workers being repurposed for things relating to COVID-19. I saw one instance, like police officers serving food. And if we get everybody out of juvenile custody and we have to use, some of the officers in order to monitor and do Zoom conversations and, otherwise sit there all day on 5 different Zooms with their, clients or their juvenile defendants, I think that's a great thing. And I think it can, radically transform things. In the meantime, anybody who's in juvenile custody is at risk. And I think any lawyer, juvenile or otherwise, should be able to get people out and come up with creative alternative sentencing right now. And so what's interesting and kind of what we put in this description for this event is that at the same time, though, as we have like these emergency release conditions, there's also statutory deadlines that are now no longer in place. And the same is the case with most juvenile delinquency proceedings and other juvenile hearings. And it says here, juvenile delinquency hearings for minors in custody must proceed under statutory timeframes. Remote appearances are allowed. Okay, so that's one area where they still are are happening. But I would just say anybody being in custody is an issue, juvenile or otherwise. So I would say try to get them out. And I think that courts will be, at least here, will be pretty amenable to it. And we just had a client in juvenile custody before COVID-19 who was on probation for grand theft. He picked up another case that was involving like robbing, with other kids, like 16-year-olds, potentially robbing this other individual, and he got out of, and the judge let him be home on, he was allowed to be home during the case and also go to school, obviously. And so I think that even before COVID-19, there has been an effort to change and not err on the side of custody. So this, I think, will change things hopefully for the better in that regard. But anybody who would get lost is too much, obviously, especially in our system that obviously says that we'd rather have a guilty person go free than convict an innocent person. We obviously don't want anybody to be dying of this. And like I said, even if somebody on death row doesn't deserve to die cruel and unusual punishment by COVID-19. So I think these are all things to discuss. And also it's important to mention in any of these motions, and you can even cite news reports about juveniles getting it, juveniles dying, young people dying. And so, because a lot of there might be misunderstandings about who can get it and who's susceptible. And then here, this Raza is showing right now, we don't agree with this headline, but it's just an example. It says, if you're a business owner on probation, don't bother to apply. I do think we could probably, in some instances, get emergency motions for probation done in order for people to be able to apply for funding.
You could do a motion to terminate probation for early termination, and then you could apply right after. But there's still the issue where the SBA is saying if you have a conviction in the last 5 years for any felony.
So mostly misdemeanor. So I'd say that
on misdemeanor probation, it's definitely worth trying to terminate it early to get eligibility for these programs.
Or what do you think, Rosie, if somebody does a quick, let's say someone has a corporation with several members, the one who's a problem owns more than 20%. I wonder if you could change the corporation where you change his percentage. Anyway, that might be something to explore.
Yeah, that person could sell their interest or something, or transfer it, as long as you're not committing some kind of fraud to the federal government.
So we have 6 minutes left. I think if anybody has any questions, I think one of the things that's been hard for me in kind of thinking about our most serious cases, our misdemeanor cases, I'm not as conflicted about at the moment, although we're trying to figure out how to utilize this to our advantage, but more like our serious case. We have this murder case in Santa Clara County. And I'm just thinking when are we going to feel comfortable enough to do a jury trial there versus does our client have to be waiting this whole time? He also has an immigration hold. So kind of balancing, someone's need for liberty with what happens to them if they continue to be in custody and they have a problem. But on the other hand, they could be in custody the rest of their life. So kind of these, I guess, issues that we didn't really think we were going to have to think about as lawyers. And then other things too, I was just contemplating having to do a preliminary hearing on Zoom. And that's strange to not be able to go up to somebody and talk to them in the hall. And at the same time, do I want to go in a mask to court? I mean, maybe that's fine. But part of being an attorney, especially, a criminal defense lawyer is kind of evoking a certain presence and drama and having to kind of figure out, is that something you can recreate on this, in this genre? How are you going to do it? And how are you going to balance your kind of rights to protect yourself and against the rights of your client who obviously has a right to a speedy trial? So I don't know if anybody has any other questions.
My head's getting woozy.
Oh. Let's see here. It says Q&A. There's 4 questions, but I'm kind of, maybe these are the ones I answered. Does anybody want to offer any advice or suggestions
Or what?
on how they're managing their criminal practice at this point? Okay. Oh.
Jackson, that's my purple hat!
Sorry about that. I would say in closing, Roz and I are both at our own houses trying to, figure out what the new rules are, working on our current matters. And if anybody has any questions or wants any of our old motions, we're happy to give them. Anything that we have habeas motions. We have motions to the Second Circuit, the Sixth Circuit, in the state courts. We have, and so if anybody even wants to, utilize anything just as even a template, we have motions for Central District Court, Northern District Court, Eastern District. And so we're happy to, share our information or direct anybody. And we hope everybody stays safe. Sorry for the screaming in the background. See, that's the thing. I'm much more persuasive in the courtroom than I am at home. So this background noise is a reflection of that, which is why I think I'd be better cross-examining a witness in court than in my house where I have no authority. And I guess those are the issues that we're going to continue to contemplate. So if anybody has any more questions, check out our website. We're trying to put everything up there we discussed, which is margolinlawrence.com. And email us. You check out our State Bar profile. You can find our emails. Find us on Facebook, or we're pretty easy to get a hold of. Call our office number. We have a 24-hour service, and we aren't doing too much, just trying to keep up on our work, make sure that we don't miss any mail. And I guess, again, the practice pointer, get your mail forwarded to your house. And everybody take care. And thank you for the opportunity. I'm so happy everybody came.